Good afternoon and welcome everyone. A brief introduction of what we're talking about today, payment, which is one of the most important issues with the construction project. In fact, most of the construction disputes that come to us are payment disputes. So what can you do about it? Ensuring payment is not as simple and straightforward as you may think. There are many considerations which we will discuss today. As with most things in construction, you should begin with the end in mind. At the beginning of the project, you need to set a strong foundation that will allow you to ensure that you get paid throughout. The topics that we'll talk about today are the pre-project planning and specifically contract negotiation, some key provisions that should or should not be in your contracts. Does the contractor have grounds to withhold payment? If the contractor's not paying you, is that a breach of contract or not? Can you stop work? You don't want to keep working if you're not getting paid and just keep digging the hole deeper, but are you allowed to? Or if you stop, would that be a breach by you? And then last, ways to get paid. On the screen is a list of some key contract provisions that you should be aware of, that you should be looking for, and if they're not there, you should be negotiating with the contractor to either add them in or to take them out, depending. The first one, a provision that authorizes you to suspend work if not paid. And we're going to talk about each of these in detail in this presentation. Next, a provision that authorizes you to terminate your contract. A provision that authorizes you to get access to the funding source, information regarding that funding source. In other words, find out if the owner has enough money to pay for the project. Then a provision that authorizes access to information for mechanics' lien rights. As we'll discuss, this is more applicable to states outside of Florida. Then a provision that authorizes you to obtain a copy of the bond if it's not recorded. A type of provision that you don't want in there is a provision that requires you to stay or stop or suspend a payment claim that you may have brought against the owner or against the bond or a lien claim. You want to get a copy of the prime contract if it's incorporated into your subcontract, and I'm sure we all know the dreaded pay if paid provision. So suspending work. The question is, can you stop work if you don't get paid? Well, it's not simple and straightforward. It depends largely on what your contract says. So you want to have this issue addressed in your contract. On the screen is an example. We're going to use some standard AIA examples throughout, and this is language from an AIA, and it would allow a subcontractor to suspend work if the GC doesn't pay. Of note, you have to provide notice. This contract language requires notice. If your language does not require notice expressly, we would suggest that you still provide reasonable notice. You want to look out for other provisions that may contradict this type of provision, such as a provision that requires you to continue performance, even if there's a dispute. Importantly here, the strike-through language, the language that is stricken here, has a line through it. That's problematic if you have a pay if paid provision. If your contract does have a pay if paid provision, you would want to remove that language. because if you have a pay if paid provision, arguably payment is not due. So within 7 days from the time payment should be made, that would not have occurred because payment should not have been made yet. Terminate the contract. This is similar to suspend your work. We don't see a lot of subcontracts that include a provision that allow a subcontractor to terminate, and that can be a big problem. This example language allows you to terminate if work has been stopped for 60 days, and that would be a good option. However, there's many other options that you would want to consider that would allow you to terminate for cause. So think through those and add those in. The bottom of this provision addresses what's your remedy. So you terminate, but then what? Well, you want to make sure you get paid after you terminate. So you want that to be spelled out in your termination provision. What if your subcontract does not include a termination provision? Well, then it depends. You're on much more shaky ground. Your right to terminate is not well founded. Legally, you can only terminate then upon a material breach of the contract. We'll talk more about this, but payment, non-payment, could be a material breach. Before any project, you should be doing due diligence on the source of funding, as well as your collateral rights, such as lien rights or bond rights. This type of provision on the screen, often called a financial assurances provision, helps you to do that. And it also helps you to be able to, throughout the project, get back under the hood and make sure that there's proper financing to complete the project. Here, this provision, again from the AIA, discusses your information, the information you need to perfect your mechanics lien rights. Not as applicable in Florida. In Florida, the construction lien law includes a notice of commencement, which we're probably all familiar with, and that is where you get your information on a Florida project for your notice to owner and your claim of lien, and you can rely on the information in a notice of commencement. But if you're doing jobs outside of Florida, the other states have different lien laws, and they may not require a notice of commencement. And in those states, you would want a provision like this to make sure you can get the information from the contractor to preserve and perfect your lien. What should you do in Florida? You would want to modify this language, and I would suggest that you require, the language requires the general contractor to record a notice of commencement and also to maintain it and to not let it expire during the project. We see that happen sometimes, and we get to the end of the project, sub comes to us, wants to record a claim of lien, and we see that the notice of commencement has expired, therefore it's no longer effective, and your lien rights don't relate back to the date the notice of commencement was recorded, which can be bad. Access to payment bond. Well, in Florida, a copy of the bond is supposed to be recorded with the notice of commencement in the public record, so you should be able to get a copy of it that way. However, that does not always happen. Some people fail to properly record the bond, and there you want the contract to give you rights to a copy of it. You would want to request it from the general contractor. And if the general contractor does not provide it to you, you're going to suffer damages from that you can hold the GC liable for. Also want to point out a good practice pointer in your notice to owner, notice to contractor. that you should be serving on just about every project. This Florida statute allows you to request a copy of the bond in that notice. And so, in our standard notices, we include that bond request. And we do that because then if, and you're serving this on the owner and the general contractor, if they fail to provide you with a copy of the bond, the statute will make them liable for any damages that you suffer due to that failure. Avoid claim stay provisions, such as the one on your screen. Courts may enforce a claim stay provision if it is drafted clearly and sufficiently enough. What does that mean? What does it mean, a claim stay provision? Well, it forces you to sit on your rights until the general contractor resolves its claims with the owner. And that's not good for you, right? You want to be able to go after your payment claim efficiently, effectively, aggressively, and now, not have to wait. The example on your screen is specific to a Miller Act lawsuit, but these types of provisions don't have to be limited to a Miller Act lawsuit. They can be broader and apply to all types of claims. Obtain a copy of the prime contract. I'm sure that many, if not most, of your subcontracts and purchase orders incorporate by reference the prime contract, the contract between the general contractor and the owner. If it does incorporate the prime contract, then you want to get a copy of it. And it's important to read. It's just as important as the subcontract language itself. When you're reading the prime contract, what are you really looking for? Inconsistencies between the two. What does the prime contract say about paying subcontractors? What does it say about the owner having to pay the contractor? That's relevant as well. What does it say about the contractor's right to suspend or terminate in relation to not getting paid? If they are inconsistent, if the prime contract says something different than the subcontract, well, which one controls? Of note there is there a flow down provision in your subcontract? Does the subcontract flow the rights and obligations down from the prime contract to you? In other words, do you get to stand in the shoes of the contractor and enforce the rights that the contractor has against the owner? The dreaded pay if paid provisions, becoming more and more common. We're seeing subcontractors being forced to accept pay if paid provisions, and many of them are, unfortunately. So what do you do if the general contractor won't let you take a pay if paid provision out of the contract? We'll talk about some other solutions later in the presentation on dealing with pay if paids, but some ideas would be to limit the time period of the allowed non-payment. They're typically open-ended, but you could write in that you're only accepting pay if paid for a non-payment period of 30 days or 45 days. Pick a number. But the point is that after some duration, that pay if paid goes away, because you should not have to stick around on the job and keep working for 90 days, 120 days without getting paid. Suspension rights. If you have a suspension provision, that if written properly, that could be a way around a pay if paid provision. And then what does the prime contract say about it? Some prime contracts obligate the general contractor to pay its subs before the owner pays the general contractor. So that could be helpful for you. just want to point out the difference between pay if paid and pay when paid. There is an important difference in Florida law. If the pay if paid provision isn't written clearly enough, the highlighted language at the bottom of the screen, subject to the express condition precedent, that's the type of clear language that's got to be in there for the provision to be a pay if paid provision. If it's not clear enough, it'll be considered a pay when paid. And when it's a pay when paid provision, the GC still has to pay you. It's just a timing mechanism. And now I'm going to turn it over to my partner, Ryan Maloney.
Good afternoon, everyone. So Austin just covered, the contract provisions and what you can kind of do pre-contract to help yourself avoid some of these issues once you get on the project. But I'm going to cover now is, okay, you've got your subcontract done, you're on the project, and you're not getting paid. So what do you do? Well, there's a couple things. First you need to look at your contract and figure out, is there a subcontract right for the contractor to be withholding payment? And then related to that, you're going to look at, well, is there a way for me to stop work or otherwise, get payment flowing? And then finally, ways to get paid through the contract. So going on the next slide, when payment stops, you first have to find out what's the reason, and then once you learn the reason, you got to look at your subcontract and see, is there some basis upon which the contractor is properly not paying me? These listed here on the slide, these are from the standard form AIA subcontract. These are some of the reasons that the subcontract provides that the contractor may be able to withhold payment from you in whole or in part. Your particular subcontract may have less or more or different things than this, but these are the type of things that potentially can raise these type of issues where you may not have the right to get paid. For example, if there's some defective work that you haven't remedied, the subcontract may provide the contractor the ability to withhold at least partial payment to protect itself until that work is done. There's other ones here that give the contractor a little bit more discretion that can be a little bit more problematic. In particular, if you look at kind of the second from the bottom about the work's not going to be completed within the subcontract time and the unpaid balance will not be adequate to cover actual or liquidated damages for the anticipated delay. You can see where there might be a big dispute about whether that's actually true or not. But if the subcontract has a provision like that, the contractor, at least in the first instance, has a basis to withhold payment. So to sum this up, we've talked about this a lot already, but contract. The terms of your subcontract are going to be super critical on this issue regarding payment. So you make sure you know what those are and you look at that and understand whether there are potential bases for the contractor to withhold payment. So going to the next slide, once you've kind of looked at that issue, whether there are any subcontract provisions authorizing the withholding of payment, if there is no proper basis for the contractor to withhold payment, you may have the right to suspend or stop work after a certain period. That may be expressly in your contract, your subcontract, in which case you need to make sure that if there's any notice requirements to give that type of pre-notice before you suspend or stop work. You need to make sure you comply with those. And even if your subcontract is silent, if it doesn't expressly give you the right to stop work, if there is no contractual basis for the contractor to withhold payment, or there's not a proper basis, that's likely going to be considered a material breach by the contractor. And when one party materially breaches the contract, the other party, after a notice and opportunity to cure is given, typically under the law has the right not to perform further. So, again, all this is going to come back to look at your contract and what does your contract say. And the analysis here that we just went through on this slide all sort of assumes that you don't have a pay if paid provision in your contract, in your subcontract. if we go to the next slide, what happens if you do have a pay if paid provision? If there is a pay if paid provision and it's an enforceable one, like the one that Austin went through on that earlier slide that talks about express condition precedent, then you've agreed basically in your subcontractor that the contractor doesn't have a contractual obligation to pay you if it's not been paid by the owner. And in fact, the contractor will not be considered a material breach of the subcontract for non-payment if the contractor has not received payment from the owner. It has no contractual obligation to pay you if there's an enforceable pay if paid provision in the subcontract. And this can be important because if that's the case and you stop work or walk off the job and there's a pay if paid provision, there's a pretty strong risk that by you doing that, even though you're not getting paid, if the contractor hasn't been paid by the owner, if you walk off the job, you could be materially breaching the subcontract, which could expose you to potential damages for breach of the subcontract. So this can be a really tough issue for subcontractors where there's a pay if paid provision. So going to the next slide. Like I said, this can be a really difficult situation because you may be in a situation where you're not being paid for no fault of your own. There may be some kind of dispute between the owner and the contractor, and the owner hasn't paid the contractor for your work, but there's a pay if paid provision. The contractor legally doesn't have the obligation to pay you, and so you're kind of put in a dilemma of, do you keep working without payment and get yourself further in the hole, or do you risk potentially breaching the subcontract by walking off the job? And again, it's a very tough dilemma. There are some potential options of things you can try to look at or try to do to help with this. And I've kind of listed these on the slide. One of them is to obtain a copy of the prime contract. And if it's incorporated by reference into your subcontract, there may be some potential arguments that you could argue that the pay if paid provision may not be enforceable. There's a Florida Supreme Court case. It's listed here on the slide. It's the OBS Company versus Pace case. And in that case, there was a pay if paid provision in the subcontract, and it was an enforceable pay if paid provision. But the subcontract incorporated the prime contract, and the prime contract had a provision that basically said that the contractor had to pay the subcontractors before it could seek reimbursement from the owner. It was a cost plus type of general contract. And what the court said was, well, when we look at those two provisions, we find that they're ambiguous. And because they're ambiguous, the pay if paid provision is not therefore explicit enough to be an enforceable pay if paid provision. And so it's not enforceable against the subcontractor. So that was a case where the incorporation by reference of the prime contract was a way that the subcontractor was able to argue and get around the pay if paid provision. So that might be one way to potentially deal with this, rock in a hard place type of situation that we're talking about. Another thing that you might be able to do is, send a demand letter to the contractor demanding payment, identifying that nobody's identified anything wrong with your work and there's no reason for you not to be paid, and potentially copy that to the owner. And if you're going to potentially threaten to walk off the job, copy that to the owner so the owner knows that, hey, not paying these subs is going to have a very serious effect on the project. And maybe that brings the owner to the table with the contractor sooner to get some money flowing. That recently happened in a case that we're representing a paving subcontractor on, where we sent that type of letter, and lo and behold, money started flowing. So that can be effective way to do things. Another potential option is in the lien law, in section 713.16, which gives any lienor the ability to send a request to the owner for a statement of the amount due or to become due on the contract, and a copy of the contract that it has with the prime contractor. And that's another way to get the owner's attention and perhaps get some money flowing to the contractor to then flow down to you. But if none of that stuff works, you may be in a situation where, you literally, you're at the situation where you have to decide what is the better way to go. Should I continue to work at the risk of not being paid and continuing to incur damages, or should I walk off the job to mitigate my damages, but also create the risk of being in breach of the subcontract? And at some point, it's kind of a judgment call, and you have to assess the risks. And I think, the further along it is, the further you've kind of been extended, the more that if you've previously documented that there's no issues with your work and you're just not being paid for no fault of your own, at some level, you just have to make a decision and make a judgment call. And that's a tough judgment call to make, but I do think at some level you could argue that you have to mitigate your damages. You can't keep working for free, and that you were forced into walking off the job. But it's a tough decision to make, and it's going to really depend on the facts and circumstances whether you make that judgment call to take that step when there's a pay if paid provision. So the next section we're going to cover is ways to get paid, and for this section I'm going to turn it over to my partner Joby Burr.
Thanks, Ryan. In this part of the presentation, we're going to cover a number of items that hopefully will serve as ways to get you paid more quickly or to better ensure payment. The first section will cover the prompt payment laws under Florida law. They pertain to both private and public projects, mechanics liens, payment bonds, mediation, and then arbitration as two types of dispute resolution mechanisms. So try to pare this down a little bit where we're not getting too far into the weeds with the prompt payment laws under Florida law, but keep in mind that these statutes are in place for attempting to ensure prompt payment to subcontractors, and they spell out a number of ways that subcontractors can get paid more quickly. They're very similar in nature in what they allow for and the remedies that they allow for, but in the private context, 715.12 speaks to a way in which you can ensure interest on unpaid amounts, and then similar to the Prompt Payment Act governing government projects, there is a payment statute that talks about ways in which a subcontractor can bring a lawsuit if they're not paid quickly as required by the statute, and you're entitled to what we'll call a speedy hearing within a short period of time within filing the lawsuit. The public project component of the prompt payment law has a similar mechanism. Keep in mind that there is a Prompt Payment Act governing certain types of government projects. There's also one that governs local government projects, and you'll just need to either consult counsel or take a look at the statute to understand which statute you're traveling under if you are working on a public project. But at the end of the day, go back one more slide, please. At the end of the day, the payment and remedy component of the public prompt payment statute is very similar to what the private project remedy provides. Again, the speedy hearing and other types of relief. Next slide, please. So private projects, real quickly on the Prompt Payment Act, it authorizes this type of relief and entitlement to be paid when certain conditions have occurred. When you're entitled to be paid under the terms of your contract, you furnish the general contractor with a written request for payment. The general contractor has been paid for your work, and you've provided all the necessary affidavits and waivers in order for the party to make payment to you. And then keep in mind that this is the statute, this particular portion of the Prompt Payment Act requires that all payments are due interest at the statutory rate beginning on the 14th day after the payment is due. And just because there is a dispute between you and your contractor doesn't mean that they can withhold the entire payment for sums that are not subject to or affected by that dispute. That's important to keep in mind. They can't just withhold all of the payment if a portion of it is not in dispute. Prompt Payment Act, there's a number of time frames within it. Obviously applies to government contracts. Contractor has to pay you and your suppliers within 10 days after it receives payment for your work. You, as a subcontractor, are required to pay your subs within 7 days. And again, it has a interest payment component, interest rate component to it, like the Private Prompt Payment Act. And if you're not paid within 30 days of providing those labor and materials, you can then file a verified complaint in the appropriate court. And these are just a quick rundown of the different types of relief that you would be entitled to, whether it's under the Private Prompt Payment Act or the Public Prompt Payment Act. You can get an accounting, you can get a temporary injunction, and you can see there's other forms of relief there. But one important component of this is, like the other Prompt Payment Act statute governing private jobs, you get an expedited evidentiary hearing, which for anyone that's been in any sort of litigation on this webinar, you're typically not getting an evidentiary hearing or a resolution on the merits anywhere near this time frame that we're talking about in this the Prompt Payment Act. So keep that in mind. One other thing that's important to keep in mind is, if there's a bona fide dispute regarding that portion of the contract price that you're claiming is due, then you're not going to be successful in your Prompt Payment Act claim. And similarly, if you've breached the contract, that's not going to be an effective means to get paid. But what we typically see is that someone will raise that there is a dispute regarding the amount owed, and therefore the Prompt Payment Act in some circumstances doesn't have a lot of teeth when you have that sort of dispute. But if it's a not disputed amount, then it's a good piece of ammo to have in your artillery. Similarly, on this statute, you get prevailing party attorney's fees if you're successful. Next slide, please.
Hey, Jimmy, it's Austin. I just wanted to point out something here. These special remedies, a temporary injunction and prejudgment attachment, those can be really important in a certain circumstance. Sometimes when the general contractors are starting to get behind on their bills and they may be insolvent, they start robbing Peter to pay Paul. They're getting paid by the owner on your project, but they're taking that money and paying some other project with it. And it's these remedies, this cause of action, which is your tool to help you in that circumstance. You can stop them from robbing Peter and paying Paul, and make sure that the money paid by the owner for you gets paid to you.
Great point. Thanks, Austin. So other ways to get paid, some of these we have already covered in prior webinars, so we won't spend a lot of time going over the ins and outs, but probably most people on this webinar are familiar generally with mechanics liens, payment bond claims, and of course we'll get into mediation or arbitration to resolve those types of claims. But let's just quickly touch on the mechanics liens and payment bond claims component of the presentation. Mechanics liens, it's a creature of statute. We always recommend clients consult with us to make sure they don't miss any of their deadlines. But the chart here is pretty easy to follow. To the extent you're required to serve a notice to owner, you have to do that within 45 days, either prior to or within 45 days of starting your work. And then recording your lien, you've got to do that within 90 days of final furnishing your work. That's an important component, and understanding when that 90 days begins. It's maybe not as late as you think it is. And then you've got a time period within which to serve your claim of lien, and then of course file your lien foreclosure lawsuit within 1 year of recording your lien. There's obviously a lot more to the mechanics lien component of getting paid than just this one slide. We commend your attention to some prior webinars that we've done on these topics on mechanics liens and payment bond claims, which will be furnished to you in connection with this presentation. Private payment bonds, won't spend too much time on this, is similar to the mechanics lien. When you have a bond claim, you don't have lien rights. That means that you can't record a claim of lien, but you can bring a claim on the bond. And you'll just need to make sure you know that there is a bond in place when you get involved in the project. If there is a bond in place, it should be attached to the and referenced in the notice of commencement for the project. And there are strict timing requirements within which to file your bond claim and provide your notice of non-payment. Again, those are all spelled out in prior webinars that we've provided. Lawsuit on the bond has to be filed within 1 year of last furnishing. And like with an untimely lien foreclosure lawsuit, you'll lose your bond rights if you don't bring your lawsuit timely. Like private projects, you have similar public payment bond component. You cannot lien public projects, as many of you may be aware, so the only rights that you have are related to the bonds that the general contractor provides. There is a statute that governs those types of bond claims and requirements. That's 255.05, and that requires, with some exceptions, a payment bond and a performance bond to be provided for those types of projects. There is a similar federal statute which governs payment and performance bonds on federal projects. That's known as the Miller Act. Very similar in scope and very similar in requirements. Actually, the Florida 255.05 statute is called the Florida Little Miller Act, patterned after the Federal Miller Act. I'll turn over the rest of the presentation to Austin Calhoun to go over mediation and arbitration components.
Thanks, Joby. So you're unable to work it out with the contractor. What do? Well, before you file a lawsuit, mediation may be an option. Mediation is an informal settlement conference. The parties have to agree to mediation, and then they also have to agree on who the mediator will be, and it can be just about anyone. It can be another contractor. The mediator's role is not to decide the merits of the payment claim, and it's non-binding most of the time. He's just there to aid in the negotiation, but he doesn't determine the result. Look to your contract before you file a lawsuit, because the contract may require pre-suit mediation. As an alternative to court lawsuits, there is arbitration. Arbitration is a private legal determination of a dispute by an impartial third party, the arbitrator. It's somewhat similar to a court proceeding, and different than mediation. Arbitration decisions are final and binding. The result of an arbitration is akin to a judgment as a result of a lawsuit. Just like with mediation, the parties must agree to arbitration. You can't force arbitration on someone unless it's in their contract. So check your contracts, see if they contain an arbitration provision or not. On a side note, we feel that subs and suppliers on construction projects should not agree to arbitrate. We think you should stick with court. Why? Why do we think that? Well, various reasons. They're non-appealable. Unlike a judgment in a court lawsuit where you can appeal and then appeal it again to the Supreme Court if necessary, you cannot, for the most part, appeal an arbitration award. And Arbitrators aren't exactly required to follow the law. And arbitrations can be the Wild West. There's not a lot of rules that have to be followed by the parties or the arbitrator. In our experience, and this is our last reason, in our experience, arbitrators are more apt to split the baby, which really is unfortunate and doesn't please either party. Certainly not you as a sub or supplier who wants to get paid in full. Attorney's fees. Well, we mentioned this in this presentation because it's an important consideration in a payment dispute. Entitlement to fees. If you have to sue the general contractor, you need that for leverage in the payment negotiation. If the GC is going to be more likely to pay you if you have entitlement to attorney's fees. So just using an example, let's say you're owed in the range of $10,000. Well, if you're not entitled to recover fees, the GC can just sit back, not pay you, and feel pretty confident that you're not going to sue them for it, because it's going to cost you a lot more than $10,000 to pursue that lawsuit. So it doesn't make financial sense, and you're just going to drop it and let it go. And it's that reason why it's critically important to have entitlement to attorney's fees, and out of an abundance of caution, you should put that in your subcontracts. I do want to remind everyone that you must be a prevailing party, that your entitlement to attorney's fees is based on whether you're the prevailing party or not, and it's reciprocal. So, either party may become entitled to attorney's fees, whoever is the prevailing party. And it's a little gray, it's not black and white, and you're not guaranteed to recover your fees, even if you think you are the prevailing party. The court decides, and the court may decide that neither party is the prevailing party. Well, I want to thank everyone for spending their time with us today and watching this presentation. Just some key points to take away. Keep the end of the project in mind. Before you get into a project and lock yourself into it, make sure that your rights to get paid are protected. Negotiate the contract. Be mindful of key provisions that we talked about. If you haven't been paid, review your contract, understand what your rights are before you do anything, because if you react rashly, improperly, you may be in breach even though you haven't been paid. Primarily we're talking, can you stop work? That's a big decision. You need to think through that completely based on your contract rights. And remember the ways to get paid and the opportunities for you to get paid, including your lien rights. Make sure you preserve those, your bond rights the same. And then, is there any dispute resolution procedures that you want to apply?
Alrighty, thank you, Austin, and thank you, Ryan and Joby. Just as a reminder, if you are interested in submitting a question at this point, you are able to move to the upper right-hand corner of your screen and submit your question there. But for now, we have a couple of questions in the queue. The first one is, how does a pay if paid provision in a subcontract affect the subcontractor's ability to make a payment bond claim? Does someone want to take that?
Yeah, I'll take that one, Elizabeth. That's actually a really good question. Typically, what the courts in Florida have said is that the surety on the payment bond is not able to assert the pay if paid provision as a defense to a subcontractor claim on a payment bond. And that is unless the payment bond expressly incorporates the subcontract, which is not that often. So that is a potential way. If you're on a bonded project, even if you have a pay-of-paid provision in your subcontract, you may still be able to look to the payment bond for recovery.
Great, thank you, Ryan. Another one is, do you recommend pre-suit mediation?
I'll take that, Elizabeth. It depends on the type of case that it is. If the dollars at stake and the issues involved are ones that are involving a lot of dollars and a lot of complex issues, I would say that pre-suit mediation is not, in my experience, been productive. Some contracts have a pre-suit mediation requirement in it, and I think that works well for smaller matters, discrete issues that shouldn't be in litigation, that parties can potentially resolve without involving experts and doing a lot of discovery. But if it's something that involves big ticket items and defects and design claims and things like that, pre-suit mediation doesn't lend itself well to getting those types of matters resolved. Typically nobody's done the type of homework that you need to do to be able to tee those types of claims up in a pre-suit mediation. So just keep in mind that at some point, if the case gets into litigation in Florida anyway, you're going to have to mediate it, and by that time, in all likelihood, the parties will be in a position where mediation would be fruitful.
Great. And one more just came through. Someone said, I recently was on a project that did not have a recorded notice of commencement. I relied on the information in my subcontract to fill out my notice to owner. I did not know what else to do. What should I do if there is no NOC?
Hey, Elizabeth, it's Austin. I'll take this one. Good question. You know, in Florida, it doesn't happen very often that a notice of commencement is not recorded, but you know, we have seen that, and luckily the lien law statute addresses that specifically, and there's a section that says, you know, what you do when there is no notice of commencement, and it says you look to the building permit application, which is interesting, but you're able to, you know, go to the building department and get a copy of the building permit application, and you can safely rely on the information therein to provide your notice to owner and notice to contractor, and record your claim of lien if you have to.
Alrighty, let's see. It looks like that is the end of the questions. So thank you, everyone. We appreciate you all joining us today and for tuning into our webinar. If there are any additional questions that you would like to address with any of our presenters, their contact information is available on our website if you would like to reach out and connect directly. That website is jimersonfirm.com. You can also always give us a call for more information at 904-389-0050. As always, if you have feedback on today's presentation, please feel free to send it to us via the link that you will receive as a follow-up to this event. Again, we appreciate your attendance and hope you all have a great rest of your week.
Thank you, everyone.